Did it. All right, take it away, Sue.
You did it, Ben. You did it.
I remembered all the things this week.
All right.
You'll get
All good? All right, here we go. Well, I am delighted to be back with you again this week as we share this time together, exploring racism in America, the history we didn't learn in school. Today, we're focusing on part 5 of 6, voter suppression, then and now. As we have traced the chronological history of our country from its founding through the civil rights movement of the 20th century, we have seen repeated examples of concerted efforts to suppress the voting power of non-white people. This evening, we will focus explicitly on the right to vote as a foundation of our democracy and the extraordinary efforts that have been expended and are in fact intensifying to this day to prevent these citizens from achieving meaningful representation. So, as is our custom, we'll start with a brief recap of last week when we focused on the criminal justice system in the United States. We looked specifically at the war on drugs, that 25-year period of draconian legislation that created horrific consequences for millions of people. Then we considered the law enforcement incentives that arose out of much of this legislation that turned the attention of state and local and federal, newly created federal law enforcement organizations to focus on drug laws. The billions of dollars generated from these initiatives has in no small part contributed to the militarization of state and local police organizations in our country. And what we know is that in terms of mass incarceration, the United States leads the world. Not a position of to be proud of. We are home to less than 5% of the world's population, and we have 25% of the world's prisoners. And in the context of those numbers, we have seen a disproportionate impact on people of color. And what we know from our history and from studies, contemporaneous studies, is that our criminal justice system is racialized at every stage. And we have seen hundreds of examples of individual police violence against particularly Black men, people of color, that echo a legacy that began with lynching and continued through the involvement of law enforcement organizations in the country's goal to enforce racial segregation. So much of where we are today is very clearly a function of where we have been in the past. So today, we will turn our attention to voter suppression from the beginning and to the current time. We're going to look at a historical framework of voting rights for our country, then consider the path to representation for African Americans following the end of the Civil War, the adaptive tactics of the white majority that took effect following the end of Reconstruction that led to nearly 100 years of direct assaults on African Americans, on Black people's right to vote. Much of this was addressed by the landmark Voting Rights Act of 1965. We have talked about it before, but today we will look at the specifics of that Voting Rights Act and also the Supreme Court decision in 2013 of Shelby County v. Holder that gutted the Voting Rights Act and ushered in what we see today as a continuing assault on voting rights. So to look at our historical framework, in the Declaration of Independence, the first description of the role of voting came from author Thomas Jefferson, who wrote, "Governments are instituted among men." Now, to be clear, I know he sort of meant women too, but not really. Anyway, that would happen later. Governments are instituted among men, deriving their just powers from the consent of the governed. So that is foundational, fundamental to the United States, that the just powers of the government come from the consent of the governed, which is provided by way of the vote. The United States Constitution has relatively little to say about voting in the United States. In fact, all it says is included in Article 1, Section 4, Clause 1. And it reads, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But Congress may at any time make or alter such regulations, except as to the place of choosing senators." That's it. That's all the Constitution has to say. As a consequence, there have been numerous actions to add amendments to the Constitution over time. In fact, once we get past the Bill of Rights, the first 10 amendments to the Constitution, almost 1/3 of the successive amendments that document have. The first was the 14th Amendment, which we know was ratified in 1868, and it granted citizenship to those who had formerly been held as slaves, and it guaranteed them due process. But it turned out that in the actions of the states, that provision of citizenship was insufficient to guarantee the rights of those formerly enslaved to vote. And so as a consequence, the 15th Amendment was passed by Congress and ratified in 1870. And it read, "The right of citizens as granted in the 14th Amendment. The right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude." And so that 15th Amendment was guaranteed the right of those formerly enslaved to vote. The men formerly enslaved, the right to vote. The right of women to vote did not take effect until a little more than 100 years ago, when the 19th Amendment was ratified in 1920 that granted women the right to vote. But once again, because it was left to the states to set much of the rules about voting, as a practical matter, Black women did not gain a meaningful right to vote until the passage of the Voting Rights Act in 1965. So for 45 years, women technically had the right to vote, but that privilege, that right was not extended to Black women until 1965. In 1961, the 23rd Amendment was ratified, and it gave residents of the District of Columbia the right to vote for president and vice president. The district is still not represented in the Senate or the Congress, the House of Representatives. But since 1961, residents of the District of Columbia have been able to cast their vote for president and vice president. In 1964, a constitutional amendment was enacted to seek to prevent the ongoing efforts by the states to enact poll taxes that made it economically difficult for poorer American citizens to vote. And so the 24th Amendment outlawed poll taxes in all elections. But as we will see, even that was not sufficient to outlaw the practice. And the last constitutional amendment that dealt with voting was enacted in 1971, and it reduced the voting age across the country to 18. This was during the Vietnam War, when the draft had been enacted and 18-year-old men were being drafted and sent to fight in that war. And the consensus in the country and in Congress was that if young men could be conscripted and sent to fight in a war, they should have the right to vote for president, vice president, and Congress who were declaring these wars. An interesting side note is a little-known Snyder Act of 1924. That act granted citizenship to Native Americans, the people who were here first. And so just like the 14th Amendment said those formerly enslaved were citizens, the Snyder Act of 1924 said that Native Americans were citizens. But once again, that was a federal law. The states were still involved in setting the rules for voting. And so it was not until 1957 that the last state gave up its prohibition of letting Native Americans vote. So we have a long history of voter suppression. Much of that changed with the Voting Rights Act of 1965, which was passed by Congress in essence to enforce the 15th Amendment, which had been on the books for almost 100 years. It eliminated literacy tests and provided for a number of other actions that we'll go into a little bit later. But the passage of the Voting Rights Act of 1965 meant that that year 250,000 new Black voters registered. And it began to shift the representation across the country. We do know that the path to voting began with the start of Reconstruction following the Civil War. That's where the path began. The 13th Amendment freed the slaves, sort of, because we know the loophole was allowed to enable convict leasing and other forms of, in essence, slavery to continue to operate. We also know that all the states did not race to ratify the 13th Amendment abolishing slavery. Delaware ratified the 13th Amendment in 1901. Kentucky got around to ratifying that amendment in 1976. And Mississippi finally declared by law that slavery had been abolished in 2013. We know that the 14th Amendment had to be ratified by states in order for them to rejoin the Union following the end of the Civil War, granting citizenship and due process to those formerly enslaved. But in many states, it was an empty act. It didn't really change the way laws were implemented. And so the 15th Amendment granted the right to vote. And so there was representation of those formerly enslaved, of African Americans, Africans and their descendants. At last, the Black voting turnout, The first year that Black men were allowed to vote was nearly 90%. 600 Black state legislators were elected. 18 Black men became state executives. The governor of Louisiana was a Black man for the first time, and the last time until 1960. 18 US congressmen and 2 US senators who were elected were Black men as a consequence of the passage of the 15th Amendment. And what we saw in legislatures and in Congress were Black and white elected representatives working collaboratively together to craft laws on finance, on charitable and penal institutions, on the creation and funding of public schools. It was a ray of hope for a different kind of country. But we know that it was not very long lasting. And in fact, violence reared its head again in the context of voter suppression. The same year that the Civil War ended, 1865, the Ku Klux Klan was founded in Pulaski, Tennessee. And there were other smaller groups that followed that same year. In 1867, the Knights of the White Camellia, another major secret white supremacy group, was founded. And then in 1874, the White League was created, and in 1875, the Red Shirts. And there was a difference between the Klan and the Knights of the White Camellia. Those were secret organizations where membership was not necessarily known, publicly known. It was privately known, and it was shared among the white citizens in states and cities. But the White League and the Red Shirts were defiantly public white supremacy organizations. And all of them turned their attention to try to suppress the Black vote. You may recall from our second class a video that showed the progression of lynchings in the South during Reconstruction, 1865 to 1876, when federal troops were present to ensure that laws were followed and amendments were considered, but it didn't change behavior. There were a wide range of reasons for these lynchings, but we'll focus for the moment on the ones that specifically targeted Black people seeking to vote. On the left side of this chart, you see the year. Then you'll see a city or a state or a county. And then in parentheses in red, the number of people lynched in each instance. The blue are cities and locations in Louisiana. And you see the incredible amount of effort of violence expended in that state to keep Black citizens from voting. In New Orleans in 1866, white mobs attacked advocates who were marching to support Black voting rights and killed 33 Black people. In Camilla, Georgia in 1868, white mobs attacked Black residents who gathered to protest attempts to keep them from voting. In Opelousas, Louisiana, that same year, an estimated 200 Black people were killed over several days because they attempted to participate in the political process. In St. Bernard Parish, later that year, white mobs attacked a Black community to discourage their voting. And in Bossier Parish, Louisiana, white mobs terrorized the Black community in widespread attacks leading up to and including Election Day, killing at least 162 Black people. In McDuffie County, Georgia, that year, a man named Perry Jeffries, his wife, and 4 of their sons were attacked and lynched by white mobs targeting Mr. Jeffries for voting. And the last item listed in Hamburg, South Carolina, in violence leading up to Election Day, a white mob attacked Black men stationed at the National Guard Armory, killing 6. So the location didn't much matter. There was every effort made to keep those personally attacked, obviously, from voting, but also to send a message to the community that the simple act of voting could be fatal. And so we know that in 1876, there was a stalemate in the presidential election, the 2 candidates being Samuel J. Tilden and Rutherford B. Hayes. Samuel J. Tilden came within 1 electoral vote of being named president, but there were 4 states that did not submit their electoral votes for counting. And so Congress and the Supreme Court got together and worked out a deal, approved along party lines, 8-7, that said they would name Rutherford B. Hayes President of the United States if he would agree to end Reconstruction. And he did, and they did. And the faint hope of a more perfect union was snuffed out in a way that continued for over 100 years. And so Rutherford B. Hayes took office in 1877, and the federal troops were withdrawn, leaving the states to their own devices in terms of the laws they passed and the actions that they took. And one of the most significant occurred in 1890, when the state of Mississippi held a constitutional convention. And in crafting this new convention, it said that in order to register to vote, potential voters had to be Mississippi residents for 2 years. They had to pay an annual poll tax, and that poll tax was retroactive to when the prospective voter turned 21. So the poll tax itself was almost unaffordable for many citizens. And if you multiplied it by the number of years since the prospective voter had turned 21, it made it virtually impossible. The voters needed to pass an elaborate literacy test that required them to read and interpret a section of the Constitution, chosen by a local white poll worker, and different segments of the Constitution were given to prospective Black and prospective white voters. None of this was done in the shadows. James K. Vardaman, a Democrat who would go on to become governor and then senator from Mississippi, was one of the new Constitution's framers. And you may recall my quoting him when he said, "There is no use to equivocate or lie about the matter. Mississippi's Constitutional Convention of 1890 was held for no other purpose than to eliminate the N-word from politics. Let the world know it just as it is." Every Southern state followed suit and adopted the Mississippi Plan, but not to be here were some of the other provisions of that plan. One of the really intriguing ones was the grandfather clause. And it said that if your grandfather had been entitled to vote prior to 1867, then all of his descendants could vote and were exempt from the poll tax and the literacy test. But of course, there were no Black citizens eligible to vote prior to 1867. So the grandfather clause exempted whites from these conditions. The impact on registration was enormous. Prior to the adoption of the Mississippi Plan, Black registration rates were 90%. and they fell to less than 6% by 1892. And so, as I said, Louisiana was not to be outdone, and it held its own constitutional convention, specifically to disenfranchise African Americans. A committee chairman at the convention said, "Our purpose is, quote, to establish the supremacy of the white race." After the adoption of the Louisiana Constitution, the number of registered Black voters dropped from 130,344 to 5,320 that year. And by 1904, there were only 1,342 registered Black voters in the state of Louisiana. And by 1910, as all the states followed with the adoption of the Mississippi Plan, no Southern Black citizen could vote, 0. And as time went on and attempts were made to rectify the situation in places where it might be possible, by 1940, the registration rate, the voter registration rate for African American citizens in the South was 3%. Once there began to be opportunities for Black citizens to vote, a new process was implemented known as white primaries, because there were some Black citizens able to vote in the primaries and help determine who the candidates for the general elections would be. And so in order to keep even this small number of Black people out of the political process, the Democratic Party in many states adopted a rule that excluded them from party membership. They refused to allow Black people to be members of the party. And then they closed the primaries to everybody except party members. Well, there were those who said that must be unconstitutional and filed a petition with the Supreme Court. And in Newbury v. United States in 1921, the court ruled that political parties were private organizations and not part of the government election apparatus. And so it was perfectly fine for the political parties to refuse to allow membership to African Americans. Finally, in 1944, almost 25 years later, in Smith v. Allwright, the Supreme Court overruled that prior decision and struck down the white primary as a violation of the 15th Amendment's prohibition against voting discrimination based on race. It took them almost 25 years to figure out that the parties actually had a role to play in the election process. But that was not the end of it. Texas Democrats established a private association from which African Americans were excluded. And the members of that association held pre-primary elections, and they selected the candidates for the Democratic primaries. So African Americans registered in the party could vote in the primaries, but the pre-primaries had already determined who the candidates were going to be. And Texas continued their pre-primaries until 1953, excluding African Americans from choosing the candidates of the party. At the same time, intimidation did not stop. This is an editorial cartoon, an editorial illustration from the Miami Herald in 1940, well beyond the end of Reconstruction and Jim Crow. Other techniques were used to attempt to keep African Americans from voting, and they included sharecropper evictions. You will recall that following the Civil War, many African Americans' economic opportunity came from being sharecroppers, renting land from white landowners, and the economic system that resulted. Because of their dependence on the land, their inability to acquire land of their own, or even to accumulate much in the way of savings or wealth, an evicted sharecropper typically had nowhere to go. And so techniques were utilized where evictions were part of a systematic plan to thwart civil rights activism and prevent Black people from voting. Black men and women who registered to vote were required to provide the names of their landlord or their employer, who could then be notified that their employee was trying to vote. Newspapers printed the names of Black people who attempted to register, and white citizens' councils distributed voter lists to white merchants who then denied basic necessities and employment to African Americans who registered or even tried to register to vote. As these sharecropper evictions continued, many evicted families were forced to live in tent cities that sprang up throughout the South. In communities that most closely resemble refugee camps, entire families sheltered in fabric tents that froze in the winter with no running water and one outhouse for dozens of people. In 1960, there were 1,400 African Americans who registered to vote in Fayette County, Tennessee, and half of them were evicted from their sharecropper homes. White landowners in Greene County, Alabama, evicted at least 75 Black families in 1960. And more than 40 Black families were evicted in Lowndes County, Alabama at Christmas of 1965. White segregationist night riders would terrorize the refugee camps, firing guns into the tent cities in the middle of the night. In the 1960s, it seems inconceivable. And so all of this resistance, violent and nonviolent, legal and extra-legal, to enforcing the 15th Amendment, backed by the power of the civil rights movement, led Congress to realize that more action was necessary. And so it resulted in the passage of the landmark Voting Rights Act of 1965, called the single most significant piece of civil rights legislation ever passed by the United States Congress. There were 5 sections to the Voting Rights Act. The 3 key sections were number 2, that included language that closely followed that of the 15th Amendment. This law was being passed to be sure that the 15th Amendment would be honored. Section 4 was very pivotal in that it provided a formula for identifying jurisdictions in the country that had a history of racial discrimination and terror. And it provided that Congress could update and rewrite that formula to determine covered jurisdictions on an ongoing basis. But it was designed to identify those areas that were egregious in their actions to prevent African Americans from voting. And Section 5 provided that those targeted areas could make no change to their voting laws without getting pre-clearance from the Department of Justice. Because what had happened up until this point in time is that states just willy-nilly enacted these terribly repressive voting laws. And if somebody objected to them, they needed to file suit, they needed to work through appeals, they needed to work their way through the courts. And in the meantime, they took effect. And so the Voting Rights Act said, not anymore. You cannot enact changes to the voting rights laws in your state unless the Department of Justice clears you to do so. And it had an enormously positive effect. It also provided that the law had to be renewed every 5 years. So in 1970, Congress renewed the Voting Rights Act for another 5 years. Excuse me. When it came up for renewal again in 1975, Congress renewed the Voting Rights Act for 7 years, and they updated Section 4 to change the formula to identify jurisdictions that needed to be covered by preclearance. In 1982, when the law came up for renewal, Congress said, you know, we keep doing this. It's a great law. Let's renew it for 25 years. So they did. And in 2006, when it once again came up for renewal, Congress said, seems to be working, and they renewed it for another 25 years. The vote in the House of Representatives was 390 to 33, and the vote in the Senate was unanimous. Imagine. But the pressure continued to build. And so in 2012, Shelby County, Alabama filed suit against Eric Holder, the Attorney General of the United States, that was decided in 2013 by the Supreme Court, and it struck down Section 4, the formula for identifying the jurisdictions that had egregiously violated the rights of African Americans to vote. And the court did so, saying they're not doing it anymore. They were doing it before, but now they're not. So we don't need this. Of course, the reason they weren't doing it anymore was because this law was in effect. And so once the Supreme Court gutted the Voting Rights Act, 8 hours after that decision was issued, Texas immediately instituted a voter ID law that had been blocked by preclearance. North Carolina reduced its statewide early voting offices from 16 to 1. Alabama closed DMV offices in 8 of the 10 counties that had a Black population of more than 75%. Between 1982 and 2006, that last period of 25-year authorization, the Department of Justice had blocked 700 discriminatory voting changes, and now it was Katie bar the door. Whatever you can envision, you can enact. And the consequences were huge. And many of these changes in state laws were based on the premise of voter fraud, the myth of voter fraud, if you will. University constitutional law scholar Justin Levitt undertook a study where he looked at 1 billion votes cast between 2000 and 2014. I'm thinking Justin couldn't have been married, and he probably didn't have much of a life outside of work, because to look at 1 billion votes is a lot. Anyway, he did. And he issued a report, and he said out of the 1 billion votes that he looked at, he saw 36 potential credible voter ID violations. So, but the concept of voter ID and voter fraud took hold in the population and in many legislatures. And so various states began enacting stringent voter ID laws. A few examples: the state of Alabama issues a government photo ID to every resident of public housing in the state. That government issued photo ID is not sufficient to serve as a voter ID. You need another government issued photo ID. In Georgia, the state legislature eliminated 12 types of IDs that were perfectly fine, and they substituted 6 types of government issued photo IDs that white citizens were apt to have and Black citizens were not. Many of the IDs acceptable were issued by the Department of Motor Vehicles, but Atlanta's 2 counties, 75% of the residents were African Americans who didn't own a vehicle. And at the time, the state did not provide for an ID. You could only get a driver's license at a DMV. In Indiana, there had never been a single documented instance of voter fraud in the state's history. But they passed a law that said in order to get a driver's license or a state ID, you had to present your birth certificate. Okay, but in Marion County, Indiana, home to nearly 250,000 Black people, you had to have a driver's license as proof of ID to get your birth certificate. North Carolina, Governor McCrory focused on fraud. The North Carolina Board of Elections had analyzed nearly 5 million votes in 2016, and they found one vote that voter ID could have prevented. The legislature did a study to gather data on the IDs that Black people did or did not have, and then they tailored the list of voter IDs to favor white people. When that case made its way to the Fourth Circuit Court, the court ruled that the law had targeted African Americans, quote, with almost surgical precision. In North Dakota, the Supreme Court ruled that your voter ID had to show a street address, but Native Americans living on reservations only have post office boxes. They don't have street addresses. And in Texas, you had to get your ID, an ID from a DMV, but many counties, a third of the counties don't have Department of Motor Vehicles, and some of those require a 250-mile round trip to get your state ID. So they thought, well, we should provide another option other than a driver's license or a state ID. But we're not going to let students use their photo IDs. We will, however, enable a concealed carry permit to serve as a legal voter ID for voting. There were illegal voter roll purges. The National Voting Registration Act says that you cannot remove people from the voter rolls just because they didn't vote. It's not a use it or lose it right. And yet, millions of people were purged from voter ID rolls and had to re-register and provide whatever the state now required in order to make that happen. The cross-check program was developed in Kansas, and it said, the leaders there said, you know, there are a lot of people in the United States who are registering to vote, and they are voting in multiple states. Yep. On election day, somehow they are moving from state to state and they are voting in multiple states, and we need to root out this voter ID corruption. One example, they ran the program for the state of Iowa, and they found that there were almost 250,000 people registered to vote in Iowa who, on the basis of their first and last name and date of birth, were also registered in another state. A clear example of hordes of people seeking to vote in multiple places. The state of Iowa paid for a study to research those 240,000 matches, and they found that there were 6 that were really people registered in Iowa and somewhere else. Now, the fact that they used to live in another state and now they lived in Iowa and weren't planning to vote both places was sort of irrelevant to the process. In addition, significant action was taken in states to limit the resources available to minority precincts. Florida limited early voting stations that led to 4- and 5-hour wait times. In Indiana, counties that had more than 325,000 residents could only have one early voting site unless there was unanimous bipartisan approval by the election board. North Carolina also limited early voting stations, leading to those same 4- to 5-hour wait times. And in Ohio, there was one polling station per county, regardless of the population of that county. And then we have what happened in Florida in 2000. You may remember the hanging chads and the presidential election. Well, what happened just prior to that election in 2013, election board officials looked at the registration rolls and they found that 16% of registered voters in Florida were Black, up from 10% in 1996. And so they devised a laptop program that would be distributed to the voting locations so that as they checked voter registrations, when people came in, if there was a question, the poll worker could type a name and information into the laptop and go to the database in Tallahassee to determine whether or not the person was registered. Well, all of the majority white precincts got the laptops, but only one majority minority precinct got a laptop. In all the rest, in order to confirm voter registration, someone at the polling place had to make a phone call to someone in Tallahassee who had to look up the person in the database. And you can imagine how many of those calls went through. In addition, a disproportionate share of those archaic punch card systems were used in minority precincts. The white counties had the more modern optical scanners and lower rates of uncounted ballots. And indeed, ballot integrity programs were implemented to intimidate Black voters. Party agents, sometimes aided by local police, warned Black people seeking to vote that even innocent technical errors in their registration information, such as wrong addresses, could subject them to arrest. And they took photographs of them to imply that even later they could be arrested if there were a problem. Ben shared the story last week about the referendum and then the legislative action in Florida to prevent felons from voting. There are different rules across the country. In Maine and Vermont, you never lose your right to vote. Even if you're in prison, you're a citizen and you get to vote. 14 states in DC, you lose your right to vote while you're incarcerated, but as soon as you're released, your right to vote is restored. In 21 states, you lose your right to vote while you're incarcerated, while you're on parole, while you're on probation. And nobody has to tell you that your right to vote has been reenacted at the end of that period of time. In 13 states, you lose your right to vote indefinitely. In some of them, it requires that the governor pardon you for your crime in order for you to be able to vote again. In one state, there has to be a piece of legislation introduced with your name on it that both the House and the Senate pass in order for you to regain your right to vote. We know that gerrymandering has had a huge effect on representation. In the 2020 elections in Wisconsin, Democrats won 52% of the votes, and that translated to 39% of the seats in the legislature. In North Carolina, 50% of the votes translated to 77% of the seats. And one of the things that happens with gerrymandering, in addition to not fully representing the population, is that there are safe seats, and there are seats where there is no opponent running for election. And of course, the Supreme Court decision in 2010, known as Citizens United, said that the free speech clause of the First Amendment prohibited the government from restricting independent expenditures for political campaigns by corporations. Individual human beings are limited in terms of how much they can contribute, but not corporations. And so what we saw was that the 2020 election reinforced more changes to voting laws. 49 states introduced 440 bills to restrict voting, vote by mail, increasing voter roll purges, instituting criminal charges for aiding a voter. A friend of mine who lives in South Carolina cannot drive his disabled next door neighbor to the polls because she is not a member of his family. And we've all heard the story in Georgia that you can't give a bottle of water to someone waiting in a 4 or 5 or 6 hour line to vote. We know that these voter ID requirements continue to intensify, and in some cases, you must provide proof of citizenship. It is important to know that prior to 2006, there was not a single state that required a government-issued photo ID, not one. And today, 35 states require a voter ID, and 15 states do not. And so we're seeing the assault on early and absentee voting. In 2020, 158 million votes were cast early or absentee. 158 million votes were cast. Of those, 116 million were early or absentee. And 85 million of those were in the 33 states that propose limiting the use of early and absentee votings. And sadly, it has made voting more difficult for voters with disabilities, loosened the requirements to educate voters. If your polling place changes, the government doesn't have to let you know. And you show up to vote in the same polling place you've been going to your whole life, and it's not a polling place anymore. And they don't have to tell you where your polling place is now. And a number of these laws are actually undermining the electoral process itself by allowing for citizen-initiated election audits, investigating and prosecuting voters, civil and criminal penalties for election officials, election integrity agencies with echoes of the violence enacted earlier, removing professional election officials and enabling partisan election administration. How is this helpful? What could help is automatic voter registration, independent districting commissions, not the province of the currently elected legislature, making Election Day a national holiday, enforcing the National Voting Rights Act, and the For the People and Freedom to Vote Acts, which are stalemate that way until the composition of those two houses shifts in some way. And finally, the John R. Lewis Voting Rights Act, which is designed to reinstitute the Voting Rights Act of 1965. So we know that at the federal level, given our current stalemate, little is likely to occur. Much of the voting rights laws being enacted today are taking place at the state level. And so it is up to each of us to know what they are and to seek to make our voices heard, recognizing that governments are instituted among men and women now, deriving their just powers from the consent of the governed.